Hello, everybody, and welcome to the Fearless Floyd Show. As always, I am your host, Fearless Floyd, and today I have back on for the seventh appearance for seventh part of the Darrell Link story, A Farmer's Nightmare. And we're going to continue where we left off at part 6. We were going through the exhibits. We left off at Exhibit M, as in Mary, and now we're going to Exhibit N, as in Nancy. Anything new you want to add or anything like that, Darrell?
Well, not really. It's just a kind of a continuation from when they dismissed the bankruptcy. And then I served that non-judicial commercial lien process on them, and they had 30 days to refute it, and they didn't know what to do. So they moved to reinstate the dismissed bankruptcy. And even though the bankruptcy rules say they can't convert a farmer to an involuntary Chapter 7, they didn't know what to do, and they couldn't answer that non-judicial proceeding. So they moved to reinstate the dismissed bankruptcy, and then they didn't know what to do with it. So they went to convert it to an involuntary Chapter 7. And so where we're going to continue is where the banks and stuff joined together. It takes 3 people to convert someone to an involuntary Chapter 7. And so this is where we kind of left off. And so this is where we'll continue, where they all join together to move to convert it to an involuntary Chapter 7 for the purpose of their own protection from their own little Ponzi scheme.
Okay. All right. Well, I'm on the sharing the screen. I'm showing the Exhibit N.
Okay. Here's where Farmers Credit Services, or they filed a joiner. This was Douglas Kettering out of Yankton, South Dakota, who moved to join the Chapter 12 trustees motion. The Chapter 12 trustee, he moved to convert or to reinstate and to convert it to an involuntary Chapter 7. So here the bank is joining in with him to do that, to basically motion to vacate, alter, amend, or modify the orders of dismissal and reservation of jurisdiction in certain matters. And it talks about, where the debtor served certain filings of non-judicial basis. There's nothing about fraud. There's nothing about anything else. It's only about that commercial lien process that here down on toward the bottom, it says that the debtor served additional papers entitled Notice of Rescission and Discharge, a note, an affidavit of revocation, a signature of on powers of attorney. And the Farm Credit Services by its joiner would also state its concern as to the intent of the debtors to file fraudulent liens against their officers and attorneys, real and personal property, and these are spurious, without legal basis, that the result of these actions would result in a slander of title of any real and personal property owned by the counsel for the Federal Farm Credit Services and the officers of the Federal Farm Credit Services of the debtor by the debtor. Wherefore, this is where Farm Credit Services joins the Chapter 12 trustee in his prayer that the court vacate and alter and amend and modify that order of dismissal. And here's the purpose. Here they're calling it fraudulent liens that are spurious and without any merit and legal basis. But yet they were so fearful of it that they had to reinstate it. If they were fraudulent and didn't have no merit, then what was their purpose in trying to reinstate a bankruptcy and convert it to an involuntary Chapter 7 and then plunder all my property because of it? So go to Exhibit O. And here's a joinder of the Chapter 12 trustees motion dated October 7th. And here's Vance C. Goldhammer, attorney of record at Commercial State Bank in Wagner, South Dakota, joins the Chapter 12 trustees motion relative to the retention of jurisdiction. based on the information contained in the trustee's motion, the document, the mailing, he says that the trustee is correct, that having concerns about the debtor's retention and perhaps the debtor should be sanctioned, and that already transpired. Without retention of the jurisdiction by the bankruptcy court, there would be no prompt or suitable remedy available to the parties named in the debtor's document. So Commercial State Bank of Wagner joins the Chapter 12 trustees' motion, basically to convert to an involuntary Chapter 7. There was nothing other than these, what they identified as fraudulent and spurious liens, but yet they're using the bankruptcy court as their vehicle to protect them from liability for their little Ponzi scheme and scam that they've got going on with the banks and the bankruptcy court. And one thing that I found is that when I was actually into bankruptcy, they didn't want me to be dismissed. They were threatening me to hurry up and get me to file the plan and the schedules so I would complete a contract so I would be bound. But I seen their little scam coming on, and when I got connected with the North American Freedom Council, so I wanted out of there and I didn't want anything to do with it. And the judge did dismiss me, and he ruled that there was specifically no existence of fraud on my part, so I was out. And I believe FHA also joined in this here joiner to convert to an involuntary Chapter 7, but I couldn't find that document. So go on to Exhibit P.
Already there.
Okay, here's the order vacating the order of dismissal signed by the Judge Peter Eckert. And here is clearly a conflict of interest. And that day at that hearing, that courtroom was absolutely full. There was standing room only. And of all the parties that were listed on this non-judicial commercial process, apparently they were concerned about these fraudulent and spurious documents because they were all concerned because they all had their names listed on it. So it was all full of suits and ties and all these people that were fearful of getting caught with the scam that they were involved in. And even Judge Peter Eckert, the bankruptcy judge, had a conflict of interest. But yet he goes ahead and issues an order. And he said it is ordered that the order of dismissal entered by this court on September 29, 1994 shall be the same and hereby vacated, and the debtor's Chapter 12 bankruptcy is hereby reinstated until further order of the court. And it is further ordered that in pursuant to 11 U.S.C. 105 that the United States Bankruptcy Code, debtor Darrell Link is hereby reinstated and prohibited from filing any judicial or non-judicial liens in any city, county, state, or federal government agency, entity, office, or agency for any amount pursuant to the debtor's commercial affidavit of truth, notice of non-judicial proceeding, notice and warning of commercial grace, and statement of account. 3 counts against any of the parties or entities listed on lien debtors list, served by debtor upon the respective party designated therein. And it is further ordered, in light of the impending retirement, the undersigned bankruptcy judge case shall be immediately forthwith reassigned to Chief Bankruptcy Judge Irvin N. Hoyt. And so he goes and reinstates it with the conflict of interest and pass it off to the Chief Bankruptcy Judge, basically out of Pierce, South Dakota. So go on to Exhibit Q. And at that point, I went ahead and did an affidavit of rescission of signature and power of attorney, and basically revoked my signature on the bankruptcy petition, the cover sheet, the declaration concerning debtor schedule, and the statement of financial affairs, which are the documents that were there trying to tie me into. So I wrote it as this. It said, I, the undersigned natural individual with full powers of powers to contract and to rescind for non-applicability, non-qualification, and mistake. I do revoke and make void as per UCC section 2608, ab initio, from the beginning. All signatures of any and all instruments and any expressed or implied power of attorney therewith, in fact or assumption, signed either by me or anyone acting as agent or undersigned as it pertains to bankruptcy case 9440136. And that's the petition, cover sheet, and declaration concerning the affair. And then I, the undersigned, do hereby revoke, cancel, annul, and wipe out all that in the assumption that without my consent or knowledge as it pertains to any of the above mentioned documents and foregoing action is retroactive to the date of signatures. I further state that the notice that affidavit replaces, cancels, repudiates, discharges the obligations, the nexus existing to prior instruments listed above. This for discharge purposes for any valuable consideration alleged or duty alleged, requested, or expected, but to put the United States Bankruptcy Court back in the original position it held prior to the signing of the above referenced documents. And this was dated October 31st, 1994. And along with that was a notice, page 2 of Q, which is the notice of rescission and discharge. So this notice to you that the enclosed affidavit discharges the bankruptcy court of original obligation to perform referenced as valuable consideration the bankruptcy application dated March 21st, 1994. Thank you very much. Please further take further notice that the affidavit of revocation and rescission of signature and power of attorney, all signatures are revoked, retroactive to the date of signing, because I just recently found out that I had no right to be in your court in this bankruptcy unit based on the restrictions found in 11 USC 101 at 46, District of Columbia at 51, territories and possessions of the United States, Puerto Rico, Guam, Virgin Islands, and American Samoa. The only place it applies. In 11 USC 109A, that I must reside or domicile a place of business or property in the United States as defined in 11 USC 101-51. That is why I rescind the signatures of those documents and any related thereto and put you back in what I believe you were before the valuable consideration was petitioned for. I will give all parties 30 days to show cause why the original petition should not be rescinded based on non-applicability, non-qualification, and mistake, as required in UCC 2-608 at Section 2. The effect of this notice will become final in 30 days if no one brings forth any valid arguments to present the same by affidavit. Thank you again. God bless you. And then I signed it, and that was also entered on the 31st of October. And then Exhibit R. Here was a response, okay? Chapter 12 trustees' objection to affidavit of revocation of signature and rescission of signature and power of attorney. The notice of rescission and discharge comes Rick A. Arnell, Chapter 12 bankruptcy trustee, and the above captioned bankruptcy estate, and there objects to debtor's affidavit of revocation and rescission of signature and power of attorney. And notice of rescission and discharge as follows. Number 1, debtor filed and served his affidavit and revocation of signature and power of attorney and notice of rescission and discharge, all dated October 31st, 1994. Number 2, Chapter 12 trustee makes his objections only for the purpose of negating any attempt by the debtor to believe that his Chapter 12 bankruptcy has been rescinded and or dismissed and or discharged in any fashion. Number 3, Chapter 12 bankruptcy can only be dismissed by bankruptcy court order, and no other order has been entered by this court. The debtor needs to present this document to the United States Bankruptcy Court for the court to make determination of this action, and therefore the Chapter 12 trustees request the debtor to schedule the same for a hearing. Wherefore, the Chapter 12 trustee prays that the court to clarify and deny debtor's action pursuant to the affidavit of revocation and rescission of signature and power of attorney and notice of rescission and discharge, and for such other further relief that the court may deem just and equitable on this premise. And that was dated November 3rd, 1994. And as you see, this here document, it's not under the penalty of perjury. It's really nothing. It's really immaterial, because what I did was under the penalty of perjury, and they had 30 days to refute it under the penalty of perjury at something of the same weight. And they didn't do it. But here again, they're using a legislative tribunal to basically just railroad and run over the people. And as you notice up in the caption, the name is always in all capital letters, identifying that corporate birth certificated person as if that is property in an estate, in an entity. So we can go on to Exhibit S. And here's where, okay, the appointment and interim trustee and approval of a standing bond. So notice it's hereby given that the following interim trustee is hereby appointed, and the trustee standing bond is fixed under the general blanket bond heretofore approved. A. Thomas Pokla of Sioux Falls, South Dakota. If the trustee rejects this appointment, the United States trustee must be notified within 5 days of the date below. Otherwise, the trustee will be deemed to have accepted the appointment. And this is Wesley B. Huizinga, the United States trustee, dated December 8th. Now, here's where things get real fast. And it was like it all happened within a couple days. And so this was on December 8th. And this same day, here's up in the caption, got my name in all capital letters with the Social Security number under it. You know, bringing this here entity, this enfranchised, this presumed enfranchised entity that I withdrew from, now they're trying to drag that back in, and they go with the Chapter 7, a motion for the court's order allowing removal and sale of cattle. Comes now the duly appointed interim trustee of the above entitled matter and moves the court pursuant to Chapter 11 U.S.C. Section 363, the bankruptcy rule of procedure 2002 to 6004, and applicable local rules of this court, order granting the trustees authority to gather up and sale all the cattle owned or possession by the above named debtor pursuant to the request made of the trustee by Farm Credit Services, a secured creditor, holding the security for such cattle pursuant to the terms of the Uniform Commercial Code adopted by the state of South Dakota, and that this court required that the trustee.
What exhibit are you reading? What exhibit?
What's that?
What are you reading?
Oh, you know what? This was a little document that was attached to T. It was the motion that the trustee had.
And I'm looking for it. I can't find what you're reading. So yeah, I was lost. We were lost.
Okay. Yeah. Yep. And then this motion was filed on the 8th day of December.
Right.
Okay. And you'll see, okay, on Exhibit T, here comes the order the same day. Motion and order, same day. And, you know, no opportunity to respond or object or anything. I was given this here just a day or two later, and I rebutted it, and we'll get to that here in a little bit. And here it goes with the order allowing trustee to gather and sale cattle of the debtor. Now, this matter have coming before the court pursuant to the interim trustees ex parte motion for this court's order allowing the trustee to gather and sale cattle owned and possessed by the above named debtor, and requesting that no notice of such required to in view of the filing which have been made by the debtor therein, and the court having reviewed such motion, being familiar in the premise that the court finding good cause, therefore it is hereby ordered that the duly appointed trustee shall be allowed to gather all cattle owned or possessed by the above named debtor for the sale of the public auction. And it is further ordered that no notice of this order be required in view of the filings which have been made by the debtor therein, and it is further ordered that the duly appointed trustee account of this court for all the expenses and proceedings realized from his gathering of the cattle and the sale of the same, December 8th, 1994, signed by the Chief Judge Irvin Hoyt. Now, here, the objection is that it was these here non-judicial proceedings that the court had no jurisdiction over. The judge had a conflict of interest. I did an affidavit of revocation of signature, withdrawing all consent from the beginning on all documents regarding the petition and all that. They had 30 days to refute it by affidavit. They couldn't do it. So he just responds to it with just a plain statement, and the court goes ahead and allows them to go ahead and plunder and take everything he's got. But this is how the courts work, and it's basically a protection of the banks, and it all stems from the money orders that I used to discharge debt that were pending the determination of the substance of said money by the Attorney General. And those would discharge the obligation because it returns them back to the same state they were in before the original note was signed. Because when I signed the original note, there was really no consideration that was ever given on their part. What it was my signature that created the credit to basically back that note. And it was my assets that were used as a surety for my signature. So they never had nothing. So I returned them back to the original state, discharged the obligation, and I figured if once I got dismissed out of bankruptcy, that, okay, go ahead now, take me to state court. And we could talk about this here discharge of debt, because the Constitution says no state shall make anything but gold or silver coin lawful tender for payment of debt. Well, in the state court, the judge could maybe bring a judgment against me, but there would be no enforcement, because it would be direct violation of the mandate to the states that no state shall make anything but gold or silver coin. And there's nothing that available, and the only thing that we use is negotiable instruments to discharge debt backed by some paper security. So with that, we can go over to Exhibit U. And here's a letter from Thomas A. Pokla, and this is I should have given you one other document here, but here's a document. This is the day after they actually plundered the cattle. But I had right after this here, I got this letter on the 8th. I probably got it on the 9th or maybe the 10th. And I put together a document. Basically, it was a temporary restraining order. And basically to stay their whole process with the bankruptcy court until this is addressed. And I took it I took it up to the marshal's office, and I handed it to them, and I asked them if they would serve that, and they were to serve it right upon the judge right there in the courthouse, and the bankruptcy court, the trustee and stuff. And they looked at me, they looked at those papers. That's the first time they ever see me. He looked at those papers, and then he looked at me, and he said, we can't serve this. They had plans on coming out the next morning and to plunder the cattle and all this here. And so I had to take that, and I went over to another guy that was a paralegal there in Sioux Falls, John Heller, and he went ahead and, we made a bunch of originals. And he said, well, this one deputy would go ahead and serve it. And so I took it down to him, and he said, well, I can get this one, this one, this one. He served 3 of them that day, and he did serve that judge. And that judge, the day before they seized my cattle, seen that document, and he refused to sign it. And that was John B. Jones, the district judge there in Sioux Falls, South Dakota. But this is how it's like one big club that is all working together, and they all work to protect each other. And this is where that secret society and the loyalty really comes in a major way, because the law is really secondary, and to protect their little club's interest seems to be priority in all cases. But then I got basically a rejection a few days later, where the judge signed this on the 12th of December. John B. Jones was served that day, and he denied that temporary restraining order to stop him from coming. And well, the next morning, I was basically sitting at the table and writing out some Christmas cards and stuff. And here comes 17 vehicles in the yard, and they all, formed a little half circle around the house, and a couple marshals stand there by the front door, with their shooting glasses on and their arms there, with their pistols on the side. And there was no way I was going to walk into that mess. And I called my neighbor. I called a guy to come out with a movie camera, called my brother to come over. And there was the highway patrols and a marshal parked out on the driveway, crosswise across the driveway, with their weapons laying across the hood. I mean, it didn't look like a very friendly environment to go stick yourself out there, because I figured the first thing that would happen was that they would probably take me out and then accuse me of doing something that, to make it look good on their side, which is a very common event that takes place. But that's how that all washed out. And then Exhibit U is a letter from this here Chapter 7 bankruptcy court, the trustee. He says, please be advised that the above case has been converted to a Chapter 7 bankruptcy, and I have been appointed as trustee. As my understanding that there are CRP deficiency payments due to me, and it is the position of myself, the trustee, that such payments are property of the Chapter 7 estate, and thus should be paid over to myself as trustee. So we had some CRP payments, I guess that was, due to come basically to my name. And now he claims to own everything because the bankruptcy court converted to an involuntary Chapter 7. They said all the property now belongs to part of the bankruptcy estate. And then this is where, after this, I go ahead and this is all the way up into February, Exhibit V, and this is after they took the cattle on December 13th. But I have pictures of all that, and we can go through that next, where it'll show who was all involved, how the local sheriff, even the banker, drove by to see how things were going, and the marshals. All these people really working in harmony together, one with another. And this is how the swarm really works. It's like one big club that is at war with the people. Just like when you go into any court, you see that gold fringe flag up on the podium, on the pole, and all public buildings. They are coming at war against the people. And they're really not so much against the people as they are against that birth certificated person, that legal fiction entity that they created from your name through the registration of the birth certificates. And then they use that as the collateral for the public debt. But when you call them on their scheme of discharging with the same type of negotiable instrument, then the war starts, because you're addressing their little Ponzi scheme. And so what I did, this is dated February 3rd, Exhibit V. I did an affidavit of revocation of signature, and this is regarding Farmers Home Administration. And this is where, at this Farmers Home Administration, I brought an action against Farmers Home for the fraudulent contract, where it said you assign this property unto the government to have and to hold forever in fee simple. So what was I buying? And I said, that's an unconscionable contract. And, you know, this needs to be addressed. So I went ahead and revoked and rescinded my signature on that. And here, you know, the undersigned natural individual with full powers to contract, rescind for fraud and misrepresentation, do hereby revoke and make void, as per UCC 2-608, ab initio, all signatures on any and all instruments and any expressed implied power of attorney therewith, in fact or assumption, signed either by me or anyone acting as agent or undersigned, as it pertains to the promissory notes. And I have 3 promissory notes, one from 79, one from 1980, and one from 82. And I never missed a payment on anything on those documents. But once they converted to a Chapter 7, they come after me. I mean, it was all the bankruptcy court owned it, and I didn't owe nothing. And here was the assumption agreement, and this is where I assumed a mortgage on a neighbor. They removed a neighbor from his farm, and he just walked away. And so that was just a mile and a half up the road from where my folks lived. So I assumed that loan, and I moved up there, and that's where I had all the cattle, and I had my operation. And that was, and then I had 3 mortgage contracts, and that was on the property. And they were all recorded there in the county courthouse in Lake Andes. And then so I, the undersigned, hereby revoke, cancel, annul, repeal, dismiss, discharge, extract, withdraw, all that, as it pertains. Okay, reject, relinquish all signatures and power of attorney in or assumption with or without my consent and or knowledge, as it pertains to any of the above mentioned documents. And the foregoing action is retroactive to the date of such signatures, and the signatures on all documents referenced do not have my genuine bona fide signature, because all the legal ramifications were never explained to me. For lack of consideration, the documents were not prepared by me, and I consider them fraud on their face. I further state and notice that a promissory note negotiable instrument 82-294-04 replaces, cancels, repudiates, and discharges the obligations existing in prior instruments listed above for discharge purposes, for the valuable consideration referenced in same notes and mortgages, to put the United States of America back in the original position held prior to the date of the above referenced instruments. That the refusal of the public office money certificate and the refusal to redeem within 120 days to Capital Resources, Boonville, Indiana, has totally discharged all the obligations outstanding. A debt tendered and refused is a debt paid at law. And then there's a few court cases with House Joint Resolution 192, notes discharging notes. One note is good as any other note. And then UCC 1-201 at 24 regarding credit money. And so this was signed, and then I also did a notice of rescission of discharge. And then this notice in Exhibit V this was a notice that to you that the enclosed copy of note negotiable instrument 82-294-4 attached a copy of a letter dated all this year, and that basically identifies the notes in the mortgage. Please take further notice that the affidavit of rescission of signature and power of attorney, all signatures are revoked, retroactive to the date of signing, and is not my genuine bona fide signature, because all the legal ramifications of the mortgage and related to the documents referenced herein and still held by the former FMHA, because I just recently found out that I do not own the land that I am supposed to pay for. If the mortgages stand as they would be without revocation, the government would own the land according to the mortgages as a matter of record. That is why I rescind my signatures on those mortgages and notes and have given you back what I believe you have given me as valuable consideration. I will give you 20 days to show cause why such mortgages should not be void for lack of consideration, fraud, misrepresentation as required by UCC 2-608 at 2. Please return all promissory notes, assumption agreement, mortgages stamped, paid in full within 20 days. I consider the obligation extinguished and fully discharged. Thank you again, Darrell Link. And this was served by, it looks like a certified mail, and there was no response. So anyway, but they continued to go on, and after that, you'll see it in the pictures that will be coming here in the near future, where they absolutely just, it looked like a tornado went through the house, threw bricks through the window, and it just mutilated it. But then regarding in Exhibit W, this was an action that I filed. I filed a Title 42 action in response to plaintiff's motion for summary judgment against remaining defendants, is what this document was. But it has a list of all the people that were involved in the taking of the cattle and all those that were out there on the yard that day. And what I did is I had, like the highway patrol, I had the sheriff of that county serve the highway patrol. And the marshals, I had that also served, you know, by, I believe, the sheriffs there in Sioux Falls. But I had process servers serve a lot of this here to get this done. And it was interesting when I paid a couple of the sheriffs for the service, they held off with, I used a check, and I sent a check to basically take care of what their charge was. They held that check for at least a couple weeks, and then the bankruptcy court come in and shut down the bank accounts, and then they charged me with bouncing fraudulent checks and writing bad checks and all this kind of stuff. And I guess fortunately I had cash on hand, and I went ahead and used a money order to discharge it. But this was a little dirty game that they played. But it's like, you know, even the post offices are involved in this. And when I got a response back where I filed some action in the District of Columbia because we weren't getting anywhere in the federal district court, so I thought maybe we need to file it into the Court of Claims in DC. So I served it, and they come back and responded. They had a whole big envelope full of documents. It was ripped open totally on two sides, and I still got that, and I've got pictures of it all. And I turned it into the post office for, you know, mail tampering, because it was one of them priority flat rate envelopes. And, you know, nothing ever happened, but that stuff, you'd have to push it all the way to, you know, Bern, Switzerland, probably to, you know, get some issues addressed on that. But this is how, you know, trying to correct some of this abuse within the system is almost like impossible. I mean, I guess what I would consider an average farmer, you know, just trying to make a living. And, you know, to deal with this stuff in the courts is just beyond. And, you know, and I can thank Ray Ehrman, who was really a paralegal that did all my typing. And he was very articulate with words and helped me do a lot of research. But anyway, it was quite a change of events from what we expect from a system that we thought was honorable. I thought there was law. I thought there was courts. I thought I was actually borrowing and using real money. But once you start recognizing, you start seeing why they brought out the monopoly game in 1934 after they took the gold out of circulation. And here we basically are just little pawns in the game, circulating funny money, and they are controlling you through a legal fiction. And once you start realizing it, it's never you as a living soul in the court. It's you as a vessel or an entity representing a vessel. And they basically hold you in all capital letters, just the same as is identified on a tombstone. Somebody with all capital letters and basically civilly dead, has no rights, has no recognition to defend himself. He's incompetent. And that's how they look at us in this legal system, as incompetent persons under that legal fiction, is because the courts cannot hear a living man or woman. So with that, that kind of finishes that part, the rest of part 6. Floyd?
Yes, I have you muted because I have Jesse here in the background talking to me.
Okay. That kind of concludes that. I don't know if there's anything that you want to add to this here, but we could do this a little other part where they filed this here task force, where they put this ad in the paper on that task force where the bankruptcy court, say they detect bankruptcy fraud.
Right.
And then in that, I kind of talk about the different, the way the money and how they've deceived us into claiming they actually have money, but how even on the bills, if we recognize this here, it is really a deception that was intentional. And unless we get into it very deep, we would never know about it.
Right.
And, most people circulate these paper bills as if they're money and never even look on the bills of what it says. Between a $1 bill, there's a reason why the statement has been made that a $1 bill can basically pay for anything, because it is still recognized as lawful money, because when you cash a $1 bill, you will get the coins. And that's where Congress has been given authority to coin money and set the value thereof. So, and it used to be defined in statute, but they have since removed all that. And
right.
So a $1 is not even defined how many grains of silver and gold equals $1. Anyway, that's the case. That was the case in South Dakota since the mid 80s.
Okay. All right.
Okay. Well, thank you, Floyd. I don't know if you want to do the other part today, or did you want to do that, or what's your thoughts?
I have to run some errands, and it's Friday, 3:00, wet, rainy, muggy here in Houston. So I want to get out and be. Yeah, there's already traffic, so yeah, I've got a couple errands run. I gotta go to the post office. I gotta run by the bank, and
Okay.
I've got a couple more. So yeah, maybe this evening if I have time, I'll text you.
Okay. Let me know, and we can go with that.
Awesome. Thank you very much, Darrell. Appreciate you being here.
You bet.
Right,
Thank you, Floyd.
You
bet.
All right, there you have it, folks. Darrell Link, Farmer's Nightmare, Part 7. We're going to have Part 8. He's going to go into a little bit more. Hopefully, we can get a little conclusion on this this nightmare. It's becoming a nightmare. I get it. Everything he's done. Yeah.
You said what? 8?
Yeah, you couldn't get a key to go in.
It don't work.
Hang on, I got to go check the mail. No, yeah, number 8. Yeah. I know it's finicky like that. I don't know why. It's weird. Yeah, let me close out this video. Anyway, thank you for being here. I appreciate all you guys. Give Darrell a big round of applause. Thank you for being here, Darrell. Thanks for sharing your story, your knowledge, your research, your experiences. Like, subscribe, share, hit that notification bell, leave a comment below. Hey, I'm selling pink Himalayan crystal salt rock lamps. Well, that's a mouthful. Yeah, basically salt lamps made of pink Himalayan salt. I have pyramids. I have square blocks. I'll be putting up some more. There's 9 different shapes total. They're all on 100% marble bases. They're dimmable, so they are pretty cool. I like them enough that I was like, hey, I'm going to put those on my website and sell them. Those are cool. And I'm going to get me some. So go check them out, thefearlessfloydshow.com/store. Also have a trust class coming up in January, as well as the trust books, the trust classes, holiday specials galore. Go in there, check them all out. I am the Fearless Floyd Show across every platform. Mainly I hang out over on Telegram. So if you want to participate, go check me out over there. I am on all other social media platforms. The Fearless Floyd Show at yahoo.com. If you want to email me, I don't always reply. Of course, those of you that have my phone number, it's not hard to find. It is on the internet all over it. So just give me a jingle. I'd much rather talk to you in person than reply to an email or to a text. And with that, y'all guys have a very safe and happy weekend. If I don't talk to you any sooner, then I'll catch you in the next video. As always, please, can we have some peace in the Middle East?